The Supreme Court on abortion in Canada. No. Abortion was illegal in Canada until 1969 under Section 251 of the Criminal Code. A doctor could receive up to a life sentence for performing the procedure, and a woman up to 2 years. In 1969, Pierre Elliott Trudeau's government amended the law to make it possible for women to have abortions if the pregnancy threatened the life or health of the mother. A committee of doctors would determine whether a woman qualified for an abortion under these terms. This law can still be found in Canada's Criminal Code under Section 287. However, it has been rendered unconstitutional by the 1988 Supreme Court decision on R.V. Morgentaler. This ruling was decided with 5 in favor and 2 against. The Supreme Court decided that the abortion law was unconstitutional because it conflicted with Section 7 of the Charter of Rights and Freedoms, which states, "Everyone has a right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice." No, the majority of the court decided that Section 7 does not imply that abortion is a right. The ruling was made on the basis that getting a committee of doctors in a hospital to approve a woman's abortion was complicated and manifestly unfair. The court deemed that any delays as a result of this law would put a woman's health and security at risk and not in accordance with fundamental justice. It was essentially the lack of equal and timely access to a criminal defense in cases where continuation of the pregnancy would endanger a woman's life or health that made the law unconstitutional. The court did not say that unequal access to abortion itself was unconstitutional. The court did not say there was an inherent right to abortion under the Charter. Rather, it said the system regulating access to abortions, particularly the hospital review committees that were meant to approve abortion requests, had so many barriers and operated so poorly that it was manifestly unfair. As a result, the abortion law was struck down. The Supreme Court decision struck down the only existing law on abortion in Canada, creating a vacuum. They left it up to Parliament to strike the balance between the state's interest to protect a fetus's right to life and a woman's right to liberty. The Supreme Court judges were unanimous in declaring that the state has an interest in protecting the life of the unborn. Justices McIntyre and LaForest stated, "Historically, there has always been a clear recognition of a public interest in the protection of the unborn, and there is no evidence or indication of general acceptance of the concept of abortion at will in our society. The interpretive approach in the Charter adopted by this court affords no support for the entrenchment of a constitutional right to abortion." Here are the 3 most common misconceptions about the 1988 Morgentaler decision. Justice Bertha Wilson was the only judge that argued that Section 2 of the Charter addressing a person's liberty and freedom of conscience was being violated by the abortion law. Here is a breakdown of the rest of the judges' decisions. Constituents from Cypress Hills-Grasslands have been asking whether or not the right of a woman to abort was actually decided at the Supreme Court. Despite the fact that the Supreme Court never decided that abortion is a constitutional right, the Liberal government denied 1,559 Canadians their right in 2018 for Canada Summer Job Funding because they refused to check off the box attesting to pro-choice values on their application.